item 18A, indemnity for legal costs, report of the leader.
Yeah, in fact, if I can just add to this, clearly the previously said limit was inadequate for something of this complexity. I mean, it was a problem of the old standards, but it was highly litigious and the costs ran up, and I am pleased that that system no longer applies. And this is really to deal with the costs of Councillor Tambourides' the wording, I'm sorry, I was struggling to find the wording, and I think it's important that we do this. I hope that we can mitigate the costs slightly as indicated in the report here, but I think we should make sure that we do provide a provision that is sufficient to meet the expenditure that the Councillor has incurred in toto in this year.
Thank you, Leader. I'm also the same opinion. This member cleared his name, if you like, and of course needs that costs awarded to him for doing so. I think there is this. We need to clarify exactly how much we are going to authorise, and what I suggest is that we authorise the amounts as fully invoiced as an upper amount. Okay, but also I am also of the understanding that the member concerned also paid a personal deposit up front to his legal representatives in securing the services, and of course that also needs to be reimbursed if it's not part of the amount invoiced. Is that agreed? Councillor Ashford.
Chairman, just for the record, want to make a brief note. I endorse everything the leader says in terms of the previous standards regime we had, the manner in which changes have taken place, and the fact that we can move forward now with something that's more certain, something that's more proper, and something that's more fitting. I welcome that entirety. The only concern that I have in relation to this, and I do want to add, is quite simply the fact that whilst it's only right that someone is represented in these circumstances, I don't necessarily think that the report informs me well enough as to what it is exactly that we're agreeing in terms of the sum. I only state it that way because, of course, if there's a certain amount that someone's entitled to, are we asking that this is being agreed retrospectively? Could the matter have come back earlier? Should it have come back earlier in terms of asking for more funding? In terms of what we're agreeing, there are regularly papers here to suggest what the breakdown of those costs are, albeit that I accept the legal department would have prudently, and I'm certain of that, have looked at what costs would be recoverable by the other party or not. Would it be proper to ask for that at the end of the legal matter or to bring it before this committee? I simply raise those points because none of those points seem to have been expressly raised within this report, and I don't feel comfortable to agree it without that being there in those circumstances, albeit that I agree with the principle raised by the leader and in general that the previous standards regime was not fit for purpose. None of these sorts of things would really have arisen in those circumstances. I would have thought, and where we are now and where we're going is a lot better, but I just need more certainty in terms of where we are and what we're agreeing. I guess in the public interest.
That's great. Paragraph 9.5 states what the application is for costs. And in addition to that, I understand that the member also paid something in the region of £1,500 up front and deposit, which needs to be reimbursed also. So that's the amount I'm proposing. So the amount invoiced by his legal team plus the deposit that he paid. So that's the amount there. In terms of the other wider questions, so again, background information, we agreed an indemnity of £3,000. So what we're agreeing now is significantly more. But I don't think back then any of us really thought it would go that far, and clearly it has. It has. The decision was appealed, and the legal costs have just struck down. But that is the cost, or was the cost of the member clearing his name, which he did. I'd also like to make another point on 7.1, where it says members and officers are set out with the reports listed in paragraphs 3.1 to 3.3. That should be paragraphs 2.1 to 2.4. So never there on that report. But we are where we are. We've had an application to cover these costs. I think this does need to be brought to an end. The member was invoiced some months ago, and officers in our legal team have actually discussed the fees with the legal representatives. This I think what we need to do going forward, and I think that the change of the standards regime anyway has dealt with this, is make sure that any future disagreement between councillors cannot cost the taxpayer this amount of money. It is absolutely ridiculous, really. And I don't want to go into the ins and outs of this particular case, who was right, who was wrong, what should have been done, should it have gone this far. The fact was the system allowed these costs to be incurred, and that is not right. It is not right. And I think certainly we should ask, perhaps as an extra recommendation on this report, that we ask the Relevant Committee, whether it be this one in the future or the Constitutional Review Committee, to look at, in safeguarding the council in terms of the future costs. But I know the leader has been more involved in the new standards regime than certainly I have, and whether actually what the new standards regime now is. Are we able to say that these sort of costs will not be incurred under the new scheme?
Yes, if I can help there, Chairman. The new standards regime, it is not envisaged that legal representation would actually be necessary, in that if a member is accused and that accusation is taken forward by the three group leaders and found that there is wrongdoing, they are then referred to their individual group for punishment. I mean, this is a step above what the Secretary of State was envisaging would happen within councils. So we are being more prudent and more transparent by doing this, but it is not envisaged that legal representation would be necessary, as it would not be a litigious process.
Just briefly, I notwithstanding all the points that have been made, the only concern, again, coming from the points that you make, is this: if the matter had gone to court, if any party had racked up a certain amount of costs and then won or lost or whatever, there would be a hearing, of course, of some sort as to who would be responsible for paying part or all of those costs. And of course, the quantum of those costs, how small or high that was, would be a matter for the court. The only point I make is that if there's a cap that's in place of some sort, perhaps an organisation itself may have said we're only allowed a certain amount to be spent, regardless of how much you do spend and what a court may or may not order, where you may have asked a court to ask another party for costs, or where the organisation itself are concerned. And that's why I made the point that if in fact a certain amount was agreed, we are in essence being retrospectively asked to increase that amount from the perspective of this organisation, not from what the court would have prudently felt would be appropriate to have been paid. And I only mention the figure that's been suggested by the legal department, which is quite right. I'm sure Mr. Lustig and his officers have done it properly. They're a good department, they know what they're doing. But in terms of how much they would have to pay, had this matter have gone to court, that's probably what's suggested here. I think the wider concern is that the amount that we had set previously, internally, is that an appropriate amount that we had set at the time as a limit that we as an organisation would provide, or are we in essence agreeing that whatever a court would have thought was appropriate should in fact have been agreed at that time? Because that's retrospectively what we're asking for. So I'm only saying on this point, this will never arise again, because of course we have a far better scheme going forward, as the leader mentions. I wouldn't want to vote in favour of this, because I'm not satisfied in circumstances that retrospectively doing this would be right. But I'm not suggesting that going forward this would be an issue. They're the reason I'm mentioning that. There's no blame on either party that's gone anywhere. There's no blame on the legal department. It's an unfortunate situation that hopefully won't arise again. But I think there is a difference in terms of what cap we set and what an appropriate fee would be subject to something having gone to court. I think there's a wider issue that we consider in there.
I see the leader will still chip in, so feel free to...
If I may, I think, notwithstanding what Councillor Rushbrook has said, which is perhaps a reason why legal advice is so expensive and that it takes so long to actually express something that's essentially quite simple. If I can sum up what Councillor Rushbrook suggested, number one is suggesting that the £3,000 limit that was originally set was inadequate. Yes, of course, with hindsight it was. We know that legal members of the legal profession tend to be very comfortable people and charge a lot, and £3,000 doesn't buy a lot of legal time. And that was point one. Point two that you made, which I agree with. However, I'm not suggesting that it was any way improper that the Standards Board actually reached this decision that it did in the first place, but it did, and it was defending that decision that the tribunal later found to have been in error that caused the costs to be racked up. I think it would be quite improper not to support the councillor in this respect, and I would feel very uncomfortable in not defending a councillor's legal, not paying a councillor's legal indemnity, whoever that councillor is, whatever party. I think it is something that was racked up and that was unavoidable, and now I've gone on as long as a lawyer would have, so I'm going to stop now. Thank you.
Okay, so it's not going to happen again. Never. Good, because it is a lot of money, and yes, £3,000 in itself is a lot of money, and yes, I just sincerely hope that the new standards regime will not let this happen again. Can we read the reports with a heavy heart?
I'm abstaining, Chairman. I'm abstaining on it.
Okay, that's noted. And the report's carried, thank you. I now table a motion to exclude the press